Oh, God.
What happened this weekend?
Let's not talk
Hey,
about
I'm
that.
a long, I'm a Longhorn. Me too. You moved past it? Okay.
Let's order, I was gonna call you, let's order 2 Madeline salads and I'll go pick them up on my way here, but you know how you just think about it and then you don't execute?
I know, I do that.
Cause I know we're gonna be here a while.
How about these for Madeline?
No,
Well,
I've done really well today.
let me tell you what I had. I had a medicine ball with Starbucks. Lips now, Gracie. Then I gave her a couple of that. Last night I had tea.
You're the Madeline.
Yeah. That a salad would have been great.
I've done really well today, so I was really wanting to stop myself.
She said a salad.
Yeah, but it's been sitting out.
You were the only one. According to ours, we were missing. So we made 2 more sets. We can take
Oh, right.
No, we used to go to the
I know, to oil red,
yeah.
but like I said, everybody.
I don't know. I tried to do DoorDash one time. That wasn't good.
That didn't turn out too well.
Mr. Cuba Classic. What's that? Mr. Cuba Classic.
It is 5:57 PM. We have a quorum, and the meeting has been duly posted. Good evening, and welcome to the Board of Trustees and Superintendent's Governance Training Workshop. Please stand and join us for a moment of silence, and remain standing for the Pledge of Allegiance and salute to the flag.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Honor the Texas flag. I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Trustees present, starting on your left, in my right are Trustee Flores, Trustee Mitch K, Trustee Garcia, and Trustee Marshall. Our Superintendent of Schools, Dr. Michael Hinojosa, joins us, and I'm Justin Henry, Board President. We're going to go ahead and go on to our own discussion item, which is discussion of the board's roles, laws, regulation, board policies, and board operation procedures. You have the floor.
Okay, great. Thank you. Thank you. So we're going to try to do this a little bit different tonight and spend more time on scenarios as opposed to your board policies or the laws. And so let's start with this one. Every board member is tired of hearing Cheryl speak at every board meeting. She complains about the same things over and over. Screams and yells, causes a commotion during the board deliberation. So the board members decide that when she gets up to speak, they're going to kick her out. What do you think? No. She's a speaker. Hence the difference right there. Exactly. All right. So let's look at the board's role, the governance role, and the management role when you're looking at that. You do have pretty specific rules about your visitors to your board meetings and what they can do. They obviously cannot disrupt. They do have the opportunity, and you don't want to stop them from having the opportunity to speak. However, if they do become disruptive, then it is up to the board president to notify her that she is being disruptive and warn her that if she persists, then she's going to be asked to leave. If she does persist, then ask her to leave, and if she still persists, then ask the appropriate person who is here on your behalf to remove the person. Typically, that'd be a police officer, peace officer, something like that, security. Management's role in this is to stay out of it and to let the board handle it, and to ensure that the public is aware of the rules of conduct, and to then, when directed by the board president, assist in the removal of the individual. But this really is a board function. You control your meetings, and you control the process of your meetings. So you do have all the rights of a property owner, and you can exclude visitors, but it needs to be when it's appropriate to do so, when they're behaving in an inappropriate manner, when there's a substantial risk of harm to any person. You do have to give a verbal warning first, and then if the behavior persists, you can remove. Now there is a new law that says that when we remove someone, we have to give them a written explanation of the appeal process so that they can grieve the removal. And you can remove someone for up to 2 years. You have to post this on your website. Typically, you'll be using your GF appeal process for that, and can use the GF process, except that the law says they have to be able to get in front of the board within 90 days. So sometimes that may mean an expedited process, because typically a grievance would not get to you within 90 days. It is also appealable to the commissioner of education. We also have criminal trespass laws and penal code criminal trespass laws that are still intact and are the typical ones that you've used previously before this new law went into effect. Okay, a parent calls you and says several kids on our street walk home from school together each day. Today, all they could talk about was the sidewalk preacher who followed them home talking to them. This seriously has creeped out our kids. Can't you get him to leave the kids alone?
Can I interject for a moment?
Sure.
I apologize. I wasn't at the last meeting, so I'm not sure from a format perspective, how you're running these discussions? Are we just speaking up when we have questions? Or?
Yes, sir. Yes, absolutely.
Okay, so before you get to this scenario on the last one, when
Yes,
it
sir.
comes to criminal trespass, if there are restricted areas within this building and somebody, countervails a police presence to get into a restricted area, is that a situation where they can be or should be banned from the building for that 2-year period?
You absolutely could choose to do that, yeah,
is that
especially if they're
something-
aware that if it's posted and they're aware that they're not allowed in that area and they somehow circumvent.
So is that something that we would act on as a body to decide if we were going to do that, or it would be up to the superintendent or up to the board president? What's the procedure for deciding whether or not we were going to ban that person for the 2-year period?
If you're following the law related to the 2-year period, I think it needs to be the board.
So it would there'd be an act of the board in
Yes, sir.
open session to vote on banning that person for 2
Yes,
years?
sir. Yes, sir.
Okay, thanks.
Okay, so we got our sidewalk preacher who's following students home. What do you do? What do you do with this phone call? Do you get in the middle of it? Go meet the sidewalk preacher? Okay, well, yes, sir. Which is exactly the right thing to do. Exactly the right thing to do. You definitely want to refer it to the superintendent. You don't want to go out there yourself and start getting involved in it. You do want to, the board could choose to look at a policy. Do we monitor students once they leave our campus? Do we have that kind of a policy? And is there a policy on members of the public who come on our campus to speak? And do I want to change either one of those? Do I want the board to change either one of those? You can also talk to the individual about their right to speak to the principal if they think that there's a safety concern right on the campus. That's your governance issue. So your management is going to look at that safety issue. They're going to get the information, look and see whether or not we followed our policies and procedures. Are our students being in a situation that is safe or unsafe? Are they being treated equitably? Do we need to contact security or police? Do we need to have a conversation with this person? They will be taking the actual physical action if they determine that there is a safety issue. There may not be, but if they determine there's a safety issue, to address the safety issue and monitor the situation. Okay. Parents tells you my son's attending Pacific High School next year and will be playing football. I know he came home with a flyer about a mandatory football camp this summer, but I can't find it. Can you help me figure out who in the district can help me? I really don't want to mess up this opportunity for him. So should you find the flyer for him and transmit it for him, to him? What do you think? You have people for that, right? Okay, the reality is you have people for that. You can notify the parent about the contact information for the principal, contact information for the head football coach. If you have a concern that there is a mandatory football camp during summer and that might be a UIL violation, then certainly you would notify the superintendent about your concerns about the UIL violation. But it's not something you would bother the superintendent about related to a flyer. The superintendent, on the other hand, is going to be looking at that big picture, were UIL policies followed with relation to the mandatory camp? And if not, why not? What's going on that campus? Be working with the campus principal to address that situation. And then, of course, there'll be communication with the campus, with the parent to address the issue. Board members do have access to documents, any district document, except that confidentiality does apply. So there may be documents that can be redacted or withheld within the course of that. All right, so let's look at Board Member Alonzo, who calls the head of facilities to demand that he conduct a study of all facilities to determine what work needs to be done on any of our facilities. What did Board Member Alonzo do wrong? Sir?
Well, he's micromanaging that.
Absolutely. Absolutely. He's micromanaging. Number one, he shouldn't be calling the head of facilities at all. If he has a concern, he should be talking to the superintendent about the concern. If there is a facility study that's already done, he could get a copy of it, and he could certainly choose to review that. If there hasn't been a facility study done, then he's got to make a decision. Do I want to ask that an agenda item be placed on there for the board to order a study? Because no individual board member has the right to order an investigation. No individual board member has the right to insist that a study be conducted. The board as a whole does have that right. And so a board member could put it on an agenda for the board to consider whether or not they want to ask for that. From a management perspective, then the superintendent, if he has a concern about a board member acting in the way he did, contacting the head of facilities, I never, ever, ever recommend that the superintendent confront the board member directly. That is the board president's job. I think the more the superintendent can stay out of that, the better off you are. So notify the board president. The board president then can address it with the board member. Certainly the superintendent can provide current documents to the board. He can also tell the board, here's how much I think that kind of study would cost. You know, if we sent it out to do this kind of facility study, here's what could potentially be the cost of that, because you have a fiduciary duty and you have to make a decision whether or not you truly do want to spend your money on that. So he could give you that information, and then if the board does vote to conduct the study, then the superintendent would have that study conducted and provide that information back to the board. But it is important to remember that a trustee cannot direct the creation of documents, although the board can do so. In a board member in your official capacity, when you are acting as a board member, you do have an inherent right of access to documents. Don't have to give a Public Information Act request. The law now says you get it by the 20th day, business day after you ask for it, unless that's overly burdensome, and then you get it by the 30th business day after you've asked for it. The law does say that confidential information can be withheld or redacted, and board members who receive confidential information must maintain the confidentiality of those documents. Teacher calls to say that central administration just told me I have to process my expenses through a campus lead. I've been in this district 20 years. No one's ever questioned my integrity or said I mishandled funds. Why should this other teacher get to say whether my expenses are okay or not? I'm a good teacher. So should you as a board member ask for those expense reports and start looking into this? No, exactly, no. No, again, you want to refer it to the superintendent. You may have a policy on processing campus expenses for payment, but you can look at your policy and see if you want the board to change it. Typically what you'll be doing in a situation like that is saying, we have a policy and there's a really good reason why we have a policy. We're a very large district. We have to have very serious controls on our money, and I support that policy. You can also tell the employee about DGBA if they want to file a grievance about it. From a management perspective, you want to make sure that the superintendent will be making sure that policies and procedures were followed, that we are treating employees equitably, that this is a procedure that needs to be in place and isn't just something that the principal cooked up for one employee, that all employees are being treated equitably, and then communicate with the employees about that. So a parent calls you to say, I've got Wednesdays and Fridays off from work and I want to have lunch with my child on those days, but the school says I cannot on Fridays. This is hard on us. Can you help? I just want to spend time with my child. So do you contact the campus for the rules to give the parent about when you can come on campus? Nope, exactly, no. Again, you would refer to the superintendent the issue. You could encourage the parent to just talk to the principal, and that's really your best bet, and inform the employee or the parent about the right to file a grievance under FNG. You may want to look, do we have a policy on parental access? And I'm sure that you do. And you can make a decision about whether or not you want the board to change that policy, but typically we do allow principals to do what they believe is in the best interest of their students. From a management perspective, again, your management will want to make sure that the policies and procedures were followed, and if they weren't, why they were not. Make sure that all parents are being treated the same way and not just this one parent who can't come on Friday, and communicate with that parent to make sure that parent understands the rules. One of the things that is now in the law is that if any board member requests more than 200 pages in 90 days of information, reminded you of someone, okay. 90 days, yeah, 90 days. Then you have to post that. You have to post and say basically how much money that it cost you for you to respond to all those public Information Act requests, information requests. I'm sorry? Yes, including the time of the people doing work. I believe it was this past legislative session, if not two. Yeah, right? Yes, sir, it is current. It is current.
That implies that districts have some mechanism in place to track even the pages at the time that you're spending your time.
Yeah, there's an awful lot of new information related to public information that came out in this last legislative session. Now the school district can designate one way that you make information requests, and, two, through a website and then through an address, through a physical address, so that you can track these things better. You know, previously they could come from anywhere. A campus principal could receive a Public Information Act request. So the goal is, and your policy's been for a long time that it goes to legal services. So legal services should have the ability to monitor how much information is being requested, unless board services can do that for you too, because you typically do your request through board services. So I don't know that you have yet.
I believe we might. I think Dino had been working to set up that infrastructure. I don't know if we actually do by now.
That we formally do that and that the board be notified every time the trustee goes over 200 pages.
Let me add something that's very important right now, because I meet with my direct reports once a quarter, and in that quarter I ask them 5 questions. The third question is always about relationships. The other questions are about transforming Dallas ISD or the bond program. But one question I also asked this past quarter, and I just met with them because they had to meet with me one-on-one in September. I said, besides the superintendent, what is the biggest time interrupter that keeps you from doing your job? And I'm gonna have my secretary cut and paste, but every one of them, I think, without a doubt, said trustee trackers and trustee requests as the #1 time interrupter. And I had the most talented team that I've ever had, but they're having to do their job and respond to the trustee trackers. Now, I will get that information. I'll have my secretary cut and paste that, but I will show you the answers that I asked, and that's what my staff responded to.
Yeah, is that better? Just to keep it quantitative and objective, we should be able to spit out of the trustee tracker. If we can't, then we need to be able to, the number of requests, the pages of responses, the amount of time, preferably of senior staff invested in responding to those. And I love the idea that it needs to be public. So if we're not already at that capability level, I hope we get there in order to be compliant with state law, because we've got to be compliant with state law.
The other issue is access to student records. And student records, no one in the district is allowed access to student records unless they have a legitimate educational interest. So, for example, a teacher at one school is not entitled to see the student records of a student at another school, because there's no educational purpose for doing so. The same applies to you. You have access to student records when there's a legitimate educational interest. So, for example, if a grievance comes to you, okay, a student discipline grievance, you need to see that student's records in order to determine a decision related to the grievance. But typically you're not going to be looking at student records. Yes, sir?
When you say you have access to the student records, you're talking about the board as a whole or an individual member?
It's the same thing. Board members have access if, in their official capacity, they have a legitimate educational interest. The issue, however, is that's almost never going to happen unless it's something that needs to come to the board as a whole. okay? It's almost never, there would never be a time that an individual, that I can think of, where an individual board member would have an educational need to know a student record when the other 8 would not have that same need to know.
Can you,
Well, we do have a policy that whatever's given to one board member goes to all board members.
Right.
I was just looking at that second bullet point and trying to determine whether or not an individual board member has a right to those student records, to review those student records, or if the request has to be made by the whole board.
No, an individual board member has a right, has a statutory right of access to documents, but only when acting in their official capacity and only when there's an educational need to know. And so those two restrictions mean for the very most part, a board member does not have a right of access to student records. Okay? There are only very specific times when any board member would have an educational need to know. And that's typically when something is coming before you where you need to look at educational records in order to make a decision. That's really about the only times you're going to be looking at identifiable student records that have student names in them.
Okay, so on that bullet point, you're comfortable that student records released to the board only if legitimate educational interest, it's not to a board member?
It's both. It's both. Because the statute says, the new statute says that a board member has access to documents within the district in the board member's official capacity as long as, I say that. Confidential records can be kept confidential and can be redacted. So the only time they would get identifiable student records is when you have a need to know the student's name.
I don't want to overemphasize this point, but I think the larger issue is when does something have to be done by the whole board versus something that an individual board member can do on his or her own. And that theme probably covers other aspects of this training.
Yes.
But I think it's important to as we go through these other issues, make it clear that only the board as a whole can do this, not an individual.
Yeah, honestly, I cannot think of an example of when an individual board member in the individual board member's official capacity would have an educational need to know a personally identifiable student record when it would not be something that's being presented to the entire board. If y'all can think of an example of when that could possibly happen, but I cannot, honestly, I don't.
so actually that was just a little bit going to my question. So we have student hearings, a grievance, and the student, I want to know more about that student's disciplinary record before that incident. That only takes 5 of us to be here. So not all 9 of us are present to make that final decision. In that case, I can ask if I wanted to know, would that be an educational interest in seeing those student disciplinary records?
Would those records be part of the grievance that's coming in front of you?
Yes. I would want to know if there was a history of disciplinary issues with that student prior to a specific incident.
Yeah, certainly if a grievance was coming to you, you would have access to all of the documents that's related to that grievance. If, for example, the student had a disciplinary record from years previous that are not relevant to this, then I would say, no, you don't have an educational need to know that. It would just be what's relevant to what's coming in front of you today. You don't have an educational need to know the student's entire history.
And who gets to define educational interest?
The Family Educational Rights and Privacy Act is the one that has had that in the law for a very long time. And so we mostly rely on interpretations from there. But it is interpreted very strictly, really, that you have to be able to identify the educational interest in order to prevent disclosure of student records. It really is. Parents obviously have a right to student records, but we try very hard to keep them confidential other than that. All right. I'm going to not spend any time on the Public Information Act really now because we're going to do it later, but it is important because you've kind of got to say it up front when you talk about these things, that you as a board must keep confidential the documents that you do get that are confidential by law. Some of those are things that are confidential by common law, anything that really would impact someone's privacy rights. So if it's, for instance, a sexual misconduct investigation and you've had to look at that, that very much will impact individuals' privacy rights, and you must keep that confidential. Common law privacy, medical records, student identifiable information, advice and opinions on policy. So when your superintendent is giving you his advice and opinions on, or your deputies, anybody who's giving you their advice and opinions while you're still developing policy, that information is confidential. Personal family information, we very much try to keep that confidential. Social security numbers are protected by law. Personal email addresses of members of the public. So you have to be very careful should you receive an email from someone and then forward that email to other individuals outside the district. You're now disclosing the personal email address of a member of the public, which is prohibited. So you've got to be really careful about that. Obviously, credit card, bank account information, we don't want that information to be out. Information that would give a bidder an advantage is another common exception that we will see. Real property, because, and we talked about that last time. Attorney-client communications, because we will keep talking about that one because it's real important. Litigation information, trade secrets, and there's a new statute on that. We'll get into that later. And then some personnel records. So most personnel records are confidential, at least to some degree. For instance, evaluations are confidential. And most information on a college transcript, you are to disclose the courses that were attempted and any degrees received. Everything else on a college transcript is confidential. So for instance, the college they attended is confidential by law. The grades that they made are confidential by law. Those kinds of things are confidential. So it's just the course of study, the classes that they took, and any degree that they obtained that is public information. The certified agenda of a closed meeting is confidential. It is illegal to distribute that, to publish it. Teacher administrator evaluations are specifically confidential by law, so you cannot disclose those. Superintendent applications, except for your finalist, and then you give 21 days notice on that. Informer's privilege relates to individuals who report violations of the law, or whether it's criminal or civil law, to someone within the school district, to protect that individual from any repercussions as a result of that report.
Ms. Scott?
Yes.
1 second. So when you're saying confidential in this bullet point closed board meeting, teacher administration evaluations, that's in regards to trustees to the public,
Yes, sir.
outward facing? What about internal?
Internally, you could, if in your official capacity, you could be entitled to review an evaluation if in your official capacity you are performing a function as a trustee. So for instance, if you hear a grievance where someone is unhappy with their evaluation, you would then have the ability to look at that individual's evaluation. If you just don't like a person and you want to see what kind of evaluations they're getting, you are not entitled to look at that. That would be confidential by law. So it has to be when you are acting as a trustee in your official capacity is when you would have access to any of this confidential information,
Thank you.
especially evaluations. Things that are disclosable is some employment information such as salary. Salary is public information of all of your public employees. Completed reports and audits are public information. Many financial documents are public information. Settlement agreements are public information. So if you settle a case, typically that will be, yes, sir.
Just to interrupt you, because this has come up on the audit committee quite a bit, but audit investigation reports that are interim, that are not completed.
No, those are working papers and they are confidential
Okay,
by
and
law.
it's not considered completed
Correct.
until the audit committee has voted to complete it.
That's correct.
So if another trustee who is or is not on the audit committee gets a copy of an audit report in progress, that is considered confidential and should not be released to the public.
That's absolutely correct.
Just wanted to make that clear, because
Yes,
it
sir.
seems to happen with some regularity around here.
Yeah, no, any report that is not completed, any kind of report that's not completed is not available to the public. It is only a completed report, and then depending on what it is. Because there may even be audit reports that are still confidential when they're completed, depending on the conclusions, depending on if there's attorney-client communications in there, those kinds of things. Board policies, obviously, administrative staff manuals are public. There are criminal consequences for violations of the Public Information Act, so it is important that we do make sure that we don't disclose things that are confidential under the law.
About that. So how is it that if trustees are aware of one trustee who has leaked something confidential, what is the appropriate process to follow to make that enforcement mechanism take place?
Okay, but you have a number of options. Number one, you talk to your board president. The board president has conversations with the board member regarding the board member's conduct. Because there are criminal consequences, there is the potential for filing of criminal complaint. There is
Which
also
should be left to the board president or to any individual trustee?
well, actually, anyone can file a criminal complaint. I'm uncomfortable with board members who act outside of, serving as a board. And so my preference would be, if you're going to do something like that, that you do it as a board. But I cannot tell you that you have lost your right to file a criminal complaint, because every citizen has that right to file a criminal complaint if you're aware of
But from a
criminal
governance
conduct.
perspective, you'd prefer it to be an act of the board?
I prefer it to be an act of the board, but I cannot tell you that you've given up that right.
So does that suggest that there would be an item on the board agenda for the board to vote on filing a collective criminal complaint against one of the trustees?
Yes, sir.
Interesting.
Yes, sir. You can also make a complaint to the Attorney General. The Attorney General, there's mandamus, there's injunction. The Attorney General can take action. I've actually had the Attorney General try to do that to a board president one time who was refusing to turn over documents that, well, it was recordings that he had. And he refused to turn them over, and I could not convince the board member to do so, so I sicked the AG on him. And the AG convinced him. So, sometimes it does take a higher authority. If they don't listen to you, it may take a higher authority for them to listen and understand what the law is and to comply with the law. So,
The only caution I would give, like I tell my staff all the time, there's always three answers. Legally, you can do it. Politically and practically, how are you going to do it? The political ramification, you understand. The practical implication, if you do, and the DA won't take the charge, now you've created this monster that the DA was not going to do, because the DA, the caseload that the Dallas County DA has is incredible, and they only take certain cases, and so that's just another thing to consider under these set of rules.
absolutely. Yeah, and it can certainly be a discussion with the board, and I think, the way I read your board operating procedures, that's really what you want to do, is come together as a board and have a discussion about those things, and act as a board, talking to the individual trustee who may be acting outside his or her authority, and then as a board decide what you're going to do. You've got some options, even to censure a board member within your board operating procedures. Remove them from committees. There's a list of things that the board can do too, short of filing a criminal complaint against someone. So you do have options. I read your board operating procedures very much as an attempt to work things out among yourselves and to try to get things resolved. But I also acknowledge that sometimes that doesn't always happen. All right, so let's look at Board Member Bill, who's been talking to the cafeteria employee, and he's incensed. He comes to board meeting with a trolley cart containing cans of petit pois peas. I actually learned all about petit pois peas because I was a school lawyer. Most people don't get to do that. Some cans are out of date. He's been going to all the campuses and checking the dates on the cafeteria stock. He demands answers as to why these dusty cans are on the shelves. Did this guy do anything wrong?
He failed to taste the food.
He failed to taste the food, failed to open the cans of petit pois peas. I didn't even know that was a word until then. Well, number one, yes, obviously, he has acted outside the scope of his actions. He should not be doing his own investigation. He can certainly notify the superintendent, hey, I've heard a concern that we're feeding our kids out-of-date food. Can you check into that? And the superintendent, because that is a safety issue, will order an investigation on that and give a report to the board on it. But a single board member should not be going out there doing any kind of an investigation. Your board policies are very specific about your accessibility to the public and what you do, and I want to go over those real quickly. You're local. Number one, it says you are accessible to the public and that you will direct the public to the appropriate administrator or the appropriate resolution process when you get a complaint. And I think that's real important, is you do have two options. I know the person that you can contact. Here's that contact information, or here's the process that you can go through, a grievance process, whatever it might be. All right, so a parent tells you, after dropping off my student at Texas Elementary School, I noticed a flea market or something being set up on the parking lot next door. That's not safe. All those strangers so near the playground. Can you go remove them, please? So do you go remove the people from the flea market? No.
Yeah, right. You ready for all these phone calls?
You're ready for all the calls? Stephanie?
She left. She's not ready either.
And that is, I do think you want to really think about safety issues. You always want to make sure the superintendent knows about. You want to get those to him so that he can send them down. A lot of these things don't require the superintendent to be notified of them, but the big things, yes, definitely do. And he's got a process, according to policy anyway, he's got a process to process those. But in a situation like that, you want to direct the parent back to the principal, and you want to say, you know what, I bet the principal has already worked through this. I bet they've already made a decision how we're going to protect the students, whether it's, whatever it is, management actions such as having more teachers in the playground when the students are out there, have whatever else they may choose to do, additional fencing, whatever they may choose to do. But
Can I interject for just a second? I'm a pretty firm believer in adhering to the governance principles that you're laying out, but the reality is that if all 9 of us were emailing the superintendent about everything that we get, it would be completely unreasonable and daunting for him to handle. One of the things that I think would be particularly helpful to new trustees from an action perspective within our particular administration and our district is if new trustees had kind of if this happens, forward it to this person kind of map. Because I think the hardest thing of becoming a new trustee is knowing who to forward things to. It's not, step one is knowing not to deal with it yourself, right? But step 2 is, all your slides say refer to the superintendent. Now, in reality, it's really the superintendent or his designee.
exactly.
And the way that Dr. Hinojosa operates is not that we would forward every single thing to him. He has an expectation of his team that they're fielding our requests. And it is very difficult as a new trustee to know who it is to refer things to. So, what I would recommend that we try to put together as a training piece internally within our district is kind of a how-to guide of, if you get this, forward it to this person, you know what I mean? And here's their contact information. Because I think that I think probably took me 18 months to get right, and that's a lot of confusion with a lot of emails. And in my district, I get a couple hundred of these emails a week, which Scott Lane knows more about than he would like to know about. But you got to know who you got to forward stuff to, and here I don't think we're very good at teaching that.
We did talk about that at the last training session, that the goal for the 28th is to have a FAQ, just like that would tell people who to contact for what, so that a trustee would have a sheet, basically, that would give them that information, or several sheets. I don't know how many sheets of paper it would take, but
Lots.
that is our goal. That is our goal. Let me tell you, that is for October 28th. I think it's 28th, 29th, right around then, when we come back, that we will have that for you to kind of walk through with everybody. Was there another comment?
Trustee Garcia and then Trustee Mitchell.
Yeah, I mean, I couldn't agree more on, I mean, those initial first weeks, months that you're on the board, and everybody comes to you with just even more so the things, I think just about every scenario that you presented somehow is relevant, and there's more. And then there's the who falls under what jurisdiction to handle what issue, and making sure that or can contact that community member and say confidently, this is the person who follows up with you. That is not my job. That's not my management.
Right.
That is, governance is a whole nother deal, but completely agree.
Yep, that's our goal.
Well, yeah, along those lines, though, and Dr. Hinojosa, you can correct me if I'm wrong, but I thought the liaison was supposed to be the person that in your slide, is, we should say, refer to the superintendent or your designated liaison. Now, rather than for us to kind of go through the organizational chart and try to find out who to send it to. And I've tried to do that with some exceptions, like when I know it's a bus thing, I'll copy Scott on it, even though he's not my liaison, because we know he's going to ultimately have to deal with that. But with respect to most things, I'm not really, hunting around, to the food and beverage department, to ask somebody about share tables or something like that. It just goes to the liaison, which is Stephanie in my case. And Dr. Hinojosa, what do you prefer?
Yeah, that is the intent of the liaison concept. And there's some senior staff that I don't want them being liaisons because I got them focusing on some other things. And some senior staff members have significant talent that they can handle those things and get them to the right places. So that is my intent. Obviously, it's not working because we have board members that are new that don't know where to send stuff. So we probably need to revisit that. And I was going to change the liaisons for next year because right now I have 2 people that have 3 liaisons, that are liaisons for 3 board members. I'm going to spread the love a little bit, and because those 2 people spend almost all their time working on board stuff. And actually 3 people have the 9 trustees just about. So I'm gonna change my process, and this is enlightening as well. So there are things that I need to do differently, but to answer your question, that was the intent of the liaison concept.
So I think this is a really important conversation. So to build on that a little bit, I would like to hash through whether that's actually the right structure or not. I get that. I definitely think there's a role for liaisons, and I think from a relationship management perspective, y'all need that. But my district is probably one of the more demanding from a parental and community involvement, and so I forward what. No. I have no. Scott's my liaison, and he does an excellent job. But I forward well over 100 emails a week to various people within the administration, and if I forwarded all 100 of those to Scott every week and said disperse these, that would be a major ask of Scott. And so I think he's grateful that the only ones that I email him about are the ops ones, and I send all the other ones to the other people they belong to, which I think is not only more effective in issue resolution with the community member that contacted me, but is also saving Scott a lot of time. But the only reason I'm able to do that is because I've been here for long enough to know who to forward it to. So if you really want us to contact our liaison on everything, I'm happy to comply with that. And frankly, it would make my life a lot easier. But I think it would make Scott's a lot harder and make it harder to get issue resolution on those topics.
I think we can compromise, come up with a happy medium, but this conversation is very good.
Yeah, well, I'll defer to your judgment on what you want me to do, but I would be surprised if the right answer is that we should send everything to our liaison, because I know in my case that would be a nightmare for my liaison.
Scott lives on nightmares. So. Let us take that under advisement and cause me to change the liaison concept by the end of the calendar year and maybe better define it.
Don't get me wrong, I don't want my liaison changed.
Yeah. No, the concept, not the individuals necessarily, but
Right.
the concept.
Yeah, exactly.
I guess the only piece that neither here nor there on the side of this discussion, but as a trustee or a newer trustee, it's easy to send a message to your liaison, but I think it kind of handicaps you in regards to getting the full scope of the district. It becomes a crutch. You just send it to the liaison, and get to know the liaison even better, but you're not really getting to know a lot of other folks in the district. Again, I don't know, just more input. I don't know if it's good or bad, but 2 cents.
Yeah, I think ultimately your superintendent can make a determination what's most efficient and what works best, and we can come, or he can come up with a plan. We can put it in a document for you that can help you. All right, so your local also says that your responsibility is to ensure management takes responsibility to help citizens receive information and services in areas of mandated service, including available systems and resources. So all right, let's talk about this one. I'm a parent at Sparrow Middle School. My son was served a peanut butter and jelly sandwich today. They won't let him have hot food. I know I haven't paid his lunch bill, but can't you fix it so he gets a hot lunch anyway? We've been friends for a long time. So what do you think?
You forward it to Michael Rosenberg and throw your hands over the air and you're done.
Well,
That's what I would do.
As a district, you've made a decision about, or you should have made a decision about what you do about the parents who have not paid their lunch bills. Oh, cool. All right, let's move on. All right, cool. All right, let's move on. All right. Okay, it's pretty good. All right, so your local policy also says that what is inappropriate constituent services is that a board member gets involved in the management or delivery of services, even if the problem is serious or if the board member's involvement is minimal. But a board member is not to get involved in management or the specific delivery of any services. Also says that board members may not confer special advantages to any employees, parents, or students, and the board member may not ignore the decision-making processes that are designed to be fair and equitable. Your local policy says that your superintendent tracks inquiries, sets a system to respond, and reports on those inquiries, and then gives you a quarterly report of those issues. You also end up with an annual board report of the system and the data. So with this one, we've got someone who's concerned that the basketball court at Colorado High School is brand new, but the track at Nevada High School is unusable. So what gives? Why does that trustee have more pull than you do in this single-member district area? Level of obnoxiousness never underestimate the level of obnoxiousness and the value of it. It's true. Okay, so governance issues. You probably have a facility plan. You probably have a plan for when you are going to improve facilities, and you may want to look and see where the campus is in that strategic facilities plan. You may also want to think about, do I want the board to change that plan? If it does, you put it on the agenda and propose a change. You may end up doing nothing but telling the parent we have a facilities plan. That track is on the plan. We just have to be patient as we get the money. And as we follow this plan, we will get to that facility. It could be a very simple conversation that you don't have to refer this out to anybody afterwards. So some of these can be very, very simple. There's lots of options for you. For management, they may know exactly what you're talking about and know exactly when it is a proposal. They may not, and they may need to look at a campus and see what's going on and what's going on with that facility and see whether or not they need to give it more priority. If there's been, say there's been a flood over there or something, so it wiped out the track and we didn't know about that when we made the facilities plan. So there's on-the-ground things that your management may be doing about it. Your local policy says that at your single-member district responsibilities that you will meet with parents and citizens to discuss and obtain information consistent with the Open Meetings Act. And so what that means is, if you've got a quorum there, it's a public meeting and you will post the agenda. If you alone are meeting with your parents, you are not a quorum, and so you could listen to parent concerns. You may use school facilities for those meetings, except when you're running for election, and then you cannot use the school facilities for that because you're in election period. And no school district funds, facilities, people, anything can be used for election purposes or political purposes. You may.
Can I ask a question on that?
Yes, sir.
I have a monthly meeting with a parent advisory council that I've had ever since I was elected, and it's hosted at a district building.
Okay.
Does that mean when I'm up for re-election in a few months, I have to host it somewhere else?
Yes, sir.
Even though it has nothing to do with campaigning and it's existed the whole time?
Yes, sir. Yeah, because think about it. Think about how easy it is for in that discussion for you to slip, oh, by the way, I'm running. By the way, this is what I plan to accomplish in my next term. Your policy is written such that you cannot, your local policy, and it's your local policy, so you, the board, could change this local policy. But right now, the way I interpret it as it's written, no, you could not use the facilities during election time, just because of that appearance of impropriety.
If that's a local policy, I'd suggest to the administration that we need to take a look at that, because, you know, if I completely agree with not using district resources for campaign events, but something that happens every month for 3 years and then happens during your election season is not a campaign event. So, you know, I think we need to have some reasonable interpretation of, you know, using district resources, because all that's going to cause me to have to do is to incur an expense to have somewhere to host it, which, you know, I already spend a lot of my own personal money on being a trustee in an unpaid position.
Yeah, it's
You
your
know,
board
having
policy.
me to do that further doesn't seem like the right thing to do. So,
Yeah. It is your board policy BAA local, so that may be something you do want to look at. It also, that policy does allow you to seek corporate assistance for those meetings with board approval, however. And you cannot require employees to attend those meetings. Skip this one because we've kind of got that. Teacher calls to say a pipe burst at my school today. We should have been closed till it was fixed. I called UEA and they did their best, but the principal insisted on keeping us open. We had to route the kids around dangerous standing water. Facilities people were in there. It was a mess. Can't you fire that principal? You've gotten that call a time or two, right? Right? Okay. So, can you just up and fire the principal who's standing knee-deep in water right now? It depends on how deep water is. Good answer. Okay. Well, number one, no, you cannot just fire an employee. They have contract rights, and we have very strict processes in place about them. You can request information about the issue. You can say, you know, I heard there was a safety issue. Tell me what happened. You get information on that. If there is a systemic issue on campus, you may want to look at where they are in the facilities plan to see when those kinds of issues are going to be resolved. But what you're not going to get in the middle of is any kind of a personnel issue on that. That's the superintendent's prerogative to bring those to you. You stay out of that. The superintendent and his staff, on the other hand, are going to review the response, going to look at the actions, make sure we did keep students safe. Is it a chronic problem that we need to address? Were the policies followed? Do we have health and safety concerns? And then have a conversation with the principal about, I don't expect you to have school when these students are in unsafe conditions. Could result ultimately in adverse employment consequences if a principal does not listen, but certainly redirection is appropriate first prior to any adverse employment consequences. And that is strictly within the purview of the superintendent and not the purview of the board. It is not the purview of the board until that comes to you to give notice of proposed non-renewal, for instance, or notice of intent to terminate. The other thing, under your single-member district responsibilities, under your local policy, it says you bring special needs to the attention of the board and the superintendent, but you cannot make any promises to your constituents, and you cannot have any campaign materials at district facilities. A parent complains, your administrators questioned my child for over an hour today. You better get my permission before you talk to my kid again. So what do you do? Number one, you have a policy. You have a policy about interviewing students, and I can assure you that you do not want a policy that says, yes, we'll contact every parent before we'll interview any child about any situation on campus, or you'll never get anything done. And that's the reason for the policy, and the administration has the right to interview students related to situations. But you can have the option to look at your policy and your local policy and see whether or not you want to change it. From a management perspective, yes, that kind of action would not violate your policies at this time. So there may be little that needs to be done. If it was a violation of your policy, then certainly there may be some corrective action that needs to be taken. But your campus administration then would communicate with the parent. You have board ethics in your local policy, and I'm not going to go over all those except to kind of highlight them. Equity and attitudes, that you're fair, just, and impartial and respectful of other people. Trustworthiness and stewardship, so that you are making sure that we are not squandering district resources, and that you are not making any private promises, personal promises to anyone about what you can accomplish for them. Honor and conduct, we expect you to tell the truth. Respect the majority decision as a board decision. That is very, very difficult for some people to do, especially when they disagree with a board decision, because they do have a truly heartfelt belief in their belief. And that is absolutely understandable, but as a board, your responsibility is to ultimately support whatever that board decision is, because you do act as a body corporate. Yes, ma'am.
Yeah, I am. Telling the truth and respecting majority decisions of the board. You know, I think there's a narrative that exists about our board in particular that I find really troubling, that's essentially says, you know, groups of trustees or whatever, and then sitting other trustees, and kind of, and I suppose that starts with the board president and addressing that internally, but I'm speaking out loud now, but I'm sure that procedure starts with our board president. I mean, that's nothing that ultimately, whether it's on social media or through other organizations, that there's anything outside of our board president's prerogative to take care of.
Okay, are you talking about board members who may be speaking in other forums about
like
what board members are doing?
Like they'll have their town halls or their own social media pages or whatever it is, and then essentially not telling the truth about whatever it is that we're collectively doing. And so.
Okay. Yes, then that is the responsibility of the board president, not the superintendent, but the board president, to address with the board member, to discuss, telling the truth, to discuss appropriate ways to communicate, to discuss, you know, I have seen a lot of board members over the years, for instance, go out of a closed session and discuss what was discussed in closed session. If that kind of thing should occur, to have a discussion with them about that how important it is that information not be disclosed. And then according to your local board operating procedures, then there is the potential for, if it cannot be resolved, your board operating procedures basically say if you have a concern with another board member, you talk to that board member. If it doesn't resolve anything, you talk to the board president works with the board member. If that still doesn't resolve it, then the board as a whole takes action. And so it is an escalating series of events to try to get the attention of a board member to act within the proper scope. Yes, sir.
Although I would add, the steps don't escalate to a point, even on the highest end, where there is any consequence of any significance. And one of the biggest struggles I've had in fulfilling our board obligation is that it's pretty clear in this policy that the other board members are responsible for regulating appropriate behavior of one another.
Sure.
And there's been some very egregious, very, very, criminal egregious things that most of us are aware of that other trustees have done. Some current trustees and some no longer trustees. And I've personally pursued with internal counsel advice on how far I'm supposed to take my duty to regulate the behavior of other trustees. And the bottom line answer that we get is that there's really not anything we can do about it. And, the escalating process that you're describing ends, and the worst case scenario is that, the board president puts on the agenda a vote to censure a trustee, and then we censure them, and then there's no consequences to a censure. So, there isn't actually, to Trustee Garcia's point, all of us reading this know that this doesn't happen here in DISD, and there isn't a mechanism for us to take it far enough as a group to actually change behavior. And so, there's been some talk about some changes to our policy that would actually put some teeth into it, which, I would personally advocate for, because right now, if somebody decides not to follow all these things, there's really not a damn thing that can happen.
Yeah, absolutely. You can revisit your local policy and see. The reality is that you are restricted, at least to some degree, by the law and what you can and cannot do. But yeah, absolutely. To look at that policy is a good idea. Vladimir, the trustee who ran to support a return to basics, meets with a constituent who's an advocate for the Civics for All education model. He supported the trustee during his campaign and was instrumental in his win. The constituent addresses the need for every citizen to understand what it means to be an American, and so wants every student to pass a civics course and test to graduate. On the other hand, he meets with Harry Stone, who states that he voted for Vladimir and he lives in his precinct, and he doesn't believe that students should pass a civics course or a civics test to graduate. He said he's so opposed to it that he'll campaign against Vladimir if he votes in favor of this item. So how do you resolve this, of competing ideas from your constituents?
Figure out who's right and do that.
Exactly. I had a board member tell me once that the first year he was on the board, he lost a third of his friends, and the second year on the board, he lost another third of his friends, and by his third year, he didn't have any friends left. And
It sounds like he was doing a good job.
yeah, exactly, and that's what he said, is clearly I was doing a good job. It's exactly what he said. And he ended up being board president. Right? This is not an easy job. And, it's not an easy job. And I've always found it so fascinating to watch the decision-making that goes on, and especially superintendent decision-making. What I've finally realized, especially with superintendent decision-making, is if I think about, okay, what is he thinking is in the best interest of students, I can usually almost always figure out how the superintendent is getting where he's going, because superintendents are laser focused on that, okay? What is in the best interest of these students? You are more political animals than your superintendent is, and you have to run for election. And so, yeah, it is hard. But again, you have been elected to do your very best job for the students in this district and to make a determination of what is in the student's best interest when that is presented to you for you to make decisions about. It is, on the other hand, your superintendent's prerogative and his staff's prerogative to make sure we do follow TEKS, that we do follow the curriculum required by the state, that we do implement appropriate curriculum that we think is important for our students after study, and that we are always working toward improving student achievement. Nobody wants to say anything else about Vladimir? You don't need to call the superintendent on this one. No, sir, you do not. Yay. And, in a lot of these, I gave you options of a lot of things that you could do. It's not always that you need to call the superintendent. For a lot of the minor ones, you absolutely wouldn't call the superintendent. In a small district, you absolutely would. You know, you call the superintendent when the paint is the wrong color green in the gymnasium. I mean, you know, in a small, because it's not the green of the Hornets. I mean, yeah, small school districts are different than large school districts. And so, you figure out what's the most efficient, appropriate way for you to operate to educate your students. Your board ethics policy also says you have integrity of character, that you don't surrender your judgment to any interest group or any individual at the expense of the district. You uphold all laws, and you do not disclose confidential or harmful information, which kind of covers what we were talking about before. You also have a commitment to service. Obviously, you do. Prepare for and attend board meetings, avoid personal involvement in the things that are the superintendent's duties, and to seek continuing education. So you get a phone call. When you sold us the bond issue several years ago, you said the pool would be open to the community. But every time I try to use it, it's closed for practice or a swim class or some other district thing. Don't think I won't remember this lie the next time you ask me for money. I'm tired of you stealing my money and then not following through on your promises. Gotten this one too? Okay, so what do you do? Well, number one, you should have never said the community. Yes, no, sir, you do not. You have a license to tell the truth. I know, so am I. That's why I said that. But you should never promise, yes, it's going to be open to the community, because if you're building a school pool, you're building it for the students, and they're going to get priority, and they're always going to get priority. And any district activities should get priority. So you've got to be really careful when you do make promises that, yes, it'll be open to the community when the students don't need it, as opposed to it'll be open to the community. So we do want to, and I think this kind of a thing, while you could refer it to the superintendent, it would be very easy for you to only say to the constituent, we have a facility use policy, and that facility use policy, GKC, is that right? Says very clearly students get first priority. And that's what the bonds were for, is for our students, and that's what we do. If it's a student event, they get first priority, and you leave it at that. For management, they would look at, so our students are our first priority. Are we following through with that? Are we, on the other hand, are we treating members of the public equitably when they are able to use the facilities? And then have communication with the folks. One of your board ethics rules is also that you will be student-centered, that you will be guided by what's best for all students, regardless of the student's race, color, religion, age, gender, national origin, marital status, sexual orientation, disability, veteran status, or any other protected category. And as I told you before, you've added some that are not necessarily protected by law right now, but certainly are appropriate to have in there. You also are not allowed to harass anybody. Good thing, right? Based on race, ethnicity, religion, etc. You are to report allegations if you are being harassed, and we have had board members who have been, for instance, sexually harassed. You have an obligation to report it, and we've got an obligation to attempt to do something about it. So your policy says that what you will do is you will report it, and then it will be investigated. All right, so let's talk about some other board member issues. Gustavo loves the NSBA convention. He goes every year. He attends the dinners and lunches religiously. In between, he's in his hotel room working on his job as a reporter for the local newspaper. So what do we do about Gustavo? Your policies say you can attend, but if you don't participate, then you reimburse. And I think that's a really good way to handle it, as opposed to knocking on Gustavo's door and making sure he shows up for meetings. It says on a pro rata share, you will reimburse. So if you don't show up for half the meetings, then you reimburse half the money. It makes it pretty clear. For your employees, it's kind of the same thing. Your employees, when they are paid to attend a conference, they attend the conference, or they would face adverse employment consequences, whether it be a reprimand, demand that they reimburse. If the superintendent has concerns about board members who are not participating fully when they're being paid to attend a conference, then he would refer that to the board president and let the board president address it. And Mr. Henry's going, why did I accept this job? Yeah. So board members serve without compensation. They are only reimbursed for expenses. Their spousal expenses may not be reimbursed. And that is very important. You do have a policy that lists all the perks that board members get, which basically are designed to enable you to do your job. That you have the assistance of the Office of Board Services, you've got computers, you've got emails, you've got those kinds of things that enable you to get your job done. You have membership in appropriate organizations so that you can learn about what it is you're supposed to be doing, that you do receive transportation, meals, lodging when you go to appropriate conventions. Yes, sir.
And so, to my earlier comment about having teeth in a censure policy for adverse board behaviors,
Yes.
These are all things on the last 2 pages that are perks of being a trustee, but not required by law to be provided by the district, and each of them could be eliminated as part of a censure policy.
Absolutely.
Correct? All right.
Definitely could
Thanks.
be. Yes, none of these are mandated by law at all. That is correct. And so if you have, and I have actually had that in one situation where I had a board member who just chronically went to conferences and would not show up for anything except meals. And we just don't let them go to conferences anymore. I mean, you may not have any other option. But you can absolutely do that. You're right. Any of these could be considered, the withholding of any of these could be a consequence. Yes, sir. Absolutely. You do have to keep records of your travel so that we can ensure that you are being appropriately reimbursed when you do receive reimbursement. And you cannot exceed your budget or your per diem. Your policy allows trustees to swap money around between you for travel and reimbursement. I don't know if that's ever happened or could ever happen, but it is in there. I will tell you that. Yep, it's in there.
The last time these were revised was 2013.
If you cancel, then you have to refund everything that is refundable. Let's see what else is important. We've already talked about that. Okay. Parent sends a daily email to all board members complaining about how the high school campus is treating her son. They disciplined him for pulling the fire alarm. Well, that's just terrible. How could he possibly know what trouble that would cause? It's obviously they don't like him because he's gay. Every board member responds to her every day. She also has 6 grievances pending. So what are we doing wrong here? Lawyer up, yeah. Lawyer up. Number one, she does have grievance rights, and you want to stay neutral. So you need to quit talking to her, okay? That's the most important thing, is if you know she's got 6 grievances coming before you, that's your best answer is, I see you have a grievance coming. I need to stay out of this so that I can hear you at the level 3 or level 4, whichever it is, based on your policy. Don't be responding to these kind of folks. Just stay out of it. If you think it's something important that the superintendent needs to know about, you could obviously forward it to him. Probably if you're getting an email a day, there is nothing in there that is important enough for you to forward to the superintendent because you've heard it all before and the superintendent's heard it all before. But so it's an option, it may not be one that makes sense. From a management's perspective, obviously, we don't want to discipline the gay students differently than we discipline the other students. And so there may be someone who is looking into that to make sure that we are disciplining students equitably. Your administration is also going to be handling those grievances until they get up to you. But it really is important, especially when you know there's a grievance coming, that you just stay out of it. You just stay out of it until it comes to your level. When it gets to your level, you will get a complete record of what has occurred at the other levels. And the whole point of a grievance policy is that we resolve things at the lowest level possible. Okay? So we give administration the opportunity to fix things, and give administration the opportunity to fix things, and then we get it, so that if there are errors, they can be corrected. So it really is important that we not get in the middle of those things, and we stay out of it until it gets to us, if it gets to us. The majority of them are going to be resolved before they get to you, but it is important to stay out of them. Yes, sir.
I have two questions. One, so grievance, I guess, is a formal term, but there's just the informal, I'm sending an email complaining, and that could be considered a grievance. At which point do you recommend a trustee removing themselves from the highest level of grievance process? Is it when you feel like you cannot be impartial because you've received information that is beyond the scope of maybe what's in the grievance documents? What's your recommendation to a trustee as to when they should not participate in the highest level? Because we get emails all the time with complaints that might at one point elevate to a grievance.
Sure. If all you've done is received an email, and you haven't then participated in it, you haven't, let me see the information, let me get more information. I've heard of trustees sitting in on grievances in the past. You haven't pulled yourself into it, then you probably still can be objective, just because if the only thing that happened is you received a complaint. On the other hand, as soon as you start interjecting yourself in it, you start listening, you start advising, you start sympathizing, you start empathizing, you start getting involved in it, or you do, I want to hear what happened at your level 1, or I want to be at your level 1, or you start advising an individual on what to do, what to say, those kinds of things, then you need to stay out of it. You need to
Second
you
question,
cannot be objective anymore, in my opinion.
Second question, it might be too fact-based, but when it gets to the highest level, what's the role of a trustee in a grievance hearing?
The role of a trustee at a grievance hearing is to look at all the evidence that's presented to you, is to listen to oral argument that's presented to you, and then to make a decision based on that record and nothing else that's happened before or after, just based on that record. And you as a board will deliberate, will discuss them, but it is very important that when you make your decision, you're basing it on the information that's been presented to you and oral argument that's presented to you. Your ultimate determination is going to be, was administration arbitrary and capricious? Did they act in an illegal manner? As opposed to, I just don't like that principle, whatever other reasons there could be. But that's your standard, is did they act arbitrarily and capriciously, or did they act illegally? Did administration act that way? Did I answer your question? Okay, great. Yes, sir.
Well, that's a really important discussion on that slide, and probably need to amplify that a little bit, because I think when you're brand new in one of these hearings, you're not quite sure what you're supposed to do, whether you're supposed to be finding new facts, and what kinds of questions are appropriate. What are you trying to do? Are you trying to figure out, if what was already decided was reasonable, or are you trying to figure out, if you were sitting there and you were the principal, would you have done the same thing?
Yeah, you don't ever want to you don't want to replace yourself with the principal. Your responsibility is to look at the record. You may not agree with the decisions that were made, but if they weren't arbitrary and capricious, they were based on sound educational reasons, they weren't illegal, then for the most part, your responsibility is to support your administration. They have your administration's put a lot of effort into these. They examine their actions. When they get grievances, you start looking at everything. You start looking at, did I make the right decision? Did I take any action? That was inappropriate? Should this issue be resolved? You don't want to come here in front of the board and all of a sudden now I as a board member have additional information that is not part of this record. So while you can certainly ask questions of any of the parties that come before you in a grievance, it's not appropriate for you to do your own fact finding. You should be making a decision based on the facts that are presented to you and not other things that you may know or think that you know.
Okay, going back to that discussion about frequently asked questions and examples.
Yes.
This is an area where a couple of examples might really be appropriate to help people understand what they're supposed to do, what their obligations are, what the scope of their authority is.
Okay.
Okay, thank you.
Okay, yeah, and we're going to talk about grievances later, so we'll get into more minute details about that at that time. But it really, truly with a grievance, number one, you want to stay out of it till it gets to you, if it gets to you. Most will not. But when it does get to you, it is a decision based on the record and oral argument, and just the record and oral argument. And it is just, were they arbitrary and capricious? Were they illegal? Was administration arbitrary and capricious? Was administration illegal? And then if they were not those things, then the expectation is that you would support the administration.
So let's say theoretically,
Okay, give me a theoretical.
we have some former employee suing us, and theoretically, a trustee is in cahoots with this suing person,
Okay?
then that trustee would be basically barred from sitting on any kind of grievance related
Yes,
to
yeah,
that, right?
that trustee would definitely need to recuse him or herself. It is, your responsibility is to be objective decision maker, and you cannot be objective if you have participated in or been in cahoots with an individual on one side or the other. I have seen situations where, for instance, I listen to the board member questions and I think, oh, wow, they're in on a whole lot of information that is not in this record. So that's, as the lawyer, I get the record typically. And I may realize that this board member's had a lot of conversations outside of what is on this record. And then it's my responsibility to kind of steer that board member back or ask that board member to recuse him or herself. I had one situation with a board member who, when I got to the board level, what I discovered was that the board member's spouse would have benefited from the decision that was being made in front of the board, for instance, because the board member's spouse got the job this other person wanted, okay? And my responsibility then is to sit down with the board member and say, okay, now that I realize this, you cannot sit as an objective person because your family is going to be benefiting from this. And have that conversation and ask that person to recuse him or herself. I've also had situations where they've refused to do so and have assured me that they could be objective. And I've handled it different ways depending on whether or not I really thought that person could be objective. I have on occasion just let the record reflect whatever my concern is so that it is on the record. Other times I have trusted the person to be objective and the person was objective, so, it just depends. Any other scenarios you want to talk about here? Like I said, we are going to talk about grievances a lot more detail later, but.
And following up on those grievances, when that discussion ends here in this room and those community members leave, the interaction between another trustee that was in disagreement with the decision that was made, is that out of line?
Okay, I'm not sure I'm following you.
So
What did I
say
miss?
we all vote, it has to be a unanimous vote.
No,
the
just
grievance?
majority.
Right, majority. In the minority, those who didn't agree with the decision that was made collectively, then continue on that conversation and guiding those, whoever it was up for that grievance.
Gotcha.
That's
Okay.
out of line at
That
that
is
point?
absolutely out of line, yes,
Okay,
ma'am.
'cause
Yes,
okay.
ma'am, that's absolutely out of line. Number one, the responsibility of trustees is to respect the majority decision of the board. You may not agree with it, it's your responsibility to support it and respect it. The reality is, if you get sued, you're going to get sued as a body corporate, and everyone's going to get sued, so it is incumbent on the board to act as a body once a majority decision has been made. But number two, you don't act outside of the best interests of the district, and if you are, if the board has made a decision and then you're acting on behalf of other individuals outside of that board majority decision, you're acting against the best interests of the district. So you've got a fiduciary duty to the district that it appears you would be violating. And I'm sure I've upset somebody tonight, but I apologize if I
I have a
have.
question. We both might upset someone else. But how does it work the other way around? So,
Okay. What do you mean?
so we're talking about, I guess, a trustee giving advice to a person that has a grievance that
Yes.
loses. What about, I guess not after they lose, but what about administration giving their perspective to trustees? So just the question I asked earlier the other way around.
Okay, so you're asking
Are you
if.
then
if-
also impartial,
If
or-
administrators come to you outside of the record and tell you, you know, this is coming to you, I just want to give you my perspective on this that's coming forward, you're right, you're absolutely right. Administrators should be respecting the same thing. Sometimes it is critical for your superintendent to say, you know, you guys just need to know that this is coming. I don't want to talk to you about a lot of the facts because you're going to get it and it's going to be coming forward to you. But it is best to kind of phrase it that way so that it is clear. I'm not telling you everything right now because it is going to be important for you to hear it as an objective third party later. But is it appropriate for an administrator to, say, a campus principal to pull you aside and say, I want you to know the other side of the story that's not in the record? No, that's not appropriate either.
So what about that impartial evaluation? If that does happen, is the same thing, you need to recuse yourself from, you
Yes, sir.
recommend recusing yourself?
Yes, sir.
Just like
Yeah.
if a community
Yes,
person
sir.
came to us and said.
Yes, sir. And that's
their
why,
side.
you know, your administrators will try to be very careful about when you have a concern and they know there's a grievance coming, they'll try to be very circumspect in the information that they give you. And that's why, is because they don't want to be accused of influencing you one way or another and then you're not able to serve on the board when you get that grievance. So it's a fine line between I want information and I am now not impartial, and that your administration has to kind of walk that difficult line sometimes when you're asking for information, because they do want to be helpful to you and provide you what you've asked, but on the other hand, they don't want to put you in a situation where now you cannot be objective and cannot serve. Okay, I am going to skip over technology because I think you guys got that down. Except, let me, and if I haven't said this already, is be really careful about hitting reply all on discussions when there are board members on there, because that is now especially is an Open Meetings Act violation now that they've changed the definition of deliberation to include written deliberations, written discussions. So be very, very careful about hitting reply all. It is important with technology that we do protect confidentiality of records because it's so easy to transfer records. So you may have a hard email copy of the superintendent evaluation, and that gets out. Obviously, you have violated his rights to have that confidential. Any administrator's evaluations, any teacher's evaluations. So student records, you may get attorney advice by email. It is very, very critical that you make sure that you protect the confidentiality of that. You are required to report when you have known violations. And there are all kinds of things that are technology use violations. So I'm not going to go over those because they're all the things that you would expect them to be. All right, so let's try one more. We're going to talk board committees real quick, and then we can talk about how much longer you want to go. The board president is a big fan of conscious discipline, so she sets up a board committee to hear about the concept, to convince the board to force the superintendent to adopt conscious discipline as the only discipline allowed on any campus. See any problem with that? Not, that's right, exactly. Number one, sorry about that. You certainly as a board member can look at policies, see what your policies are regarding student discipline and whether or not you want the board to change them. You do approve the student code of conduct. Typically, the student code of conduct will not have an awful lot in it about this, but it may. It may. Your superintendent and his staff, on the other hand, are looking at this very seriously. They are continually looking at different kinds of student discipline management systems. They revise the student code of conduct every year. They will implement a student discipline management system, and they will monitor it for equity. So they're very involved in it. Your involvement is much less. Further, board committees are designed to help the work of the board, not the work of the administration. Parent calls to say, we're going on vacation over Christmas, but my student has finals when we return. How are they going to remember anything? How stupid could you be to set up the calendar that way? You decide to set up a board committee to change the calendar. Within your prerogative? You will get the calendar and you will review it. You can tell the parent about that calendar process and all of the competing interests that go into that, especially if you've been on the board a couple of years. You know how difficult it is to actually put that calendar together. You can request additional information from stakeholders and say, all right, well, tell me what is important to you. You can review calendar options with your administration. Ultimately, you will approve a calendar and can certainly ask questions of your administration, but it's your administration that are really going to sit down and try to figure out what are all the important things we've got to put on that calendar and then propose at least one, but maybe more than one calendar option for you to consider. So to talk about board committees, your responsibility is to post agendas on that if it is going to be a situation where that committee has control over public business. Otherwise, you don't need to post. If there's less than a quorum and no supervision and control, there's no need to post the agenda. The safest thing to do is just always post, and then you don't have to deal with the issue. Yes, sir.
Okay, that is our practice, but when you say quorum, let's say we have a committee, a committee of 3. Now, is a quorum 2 or is it 5?
The quorum is still 5 for you to come under the Open Meetings Act. The quorum is still 5. The risk you run is that you have a committee meeting and 5 members show up because they're interested in the topic. And so very often in a lot of my clients' cases, it's just easier for them when they do have board committees, they just go ahead and post, because any board member could attend a committee meeting.
Right. I just wanted to know technically, if do we always have to, it's good practice if we can do it, but if we only have 3 members on the committee and we can meet tomorrow even though we didn't post it.
Yes, sir.
3 days ago.
Yes, sir,
Okay.
you could.
Thanks.
All right, so board committees are designed to help the board do its job with no interference in the superintendent's duties and not giving advice to staff. Board committees do not speak or act for the board under your local policy. They do not have any authority over staff or the superintendent, and the president and the superintendent serve ex officio on all of your board committees. You do have a charter for your audit committee. Okay, I think this is probably a good time to stop this evening because I know you've got other work to do. I'm happy to answer any other questions, and we'll take it up again on October, I think it's 28th, but I could be wrong. Yes, sir. Yes, your audit committee is a committee of the whole, isn't it? Is it not? It is a 3-member. Oh, then you need to always post. Yes, sir. Yes, sir. If it has authority to act on behalf of the board, then you must post. Yes. Because you're really acting as a public body, as opposed to, for that body, yes. For that committee to act too as a quorum, if it's a 3-member. Sorry, I thought yours was a committee of the whole. Okay,
So
okay.
just on, let's take the audit committee
Yes, sir.
and the walking quorum issue. So if you've got a 3-member committee and 2 members are talking to each other, do you have a walking quorum of that audit committee, or is the walking quorum only a concern when you're talking about the committee of the whole?
If we've posted it, it is a committee that has the authority to act, then yeah, 2 could be a walking quorum. I mean, that was the case with the commissioners. There was a 3-member body, and they went to the restroom together, and 2 of them were talking.
But 3 was the whole.
If 3 is the whole, then 2 is a quorum, yes.
Okay.
Yes.
Well, yeah,
So
if you would just, think about that, because it's even hard to schedule a meeting when you've got 3 people without talking to each other. Like, are you available on Saturday? We're having emails going back and forth. It's just one person talking to another person, and if we have to deal with it, we will. But I just kind of see that one as being
Okay, yeah, I'll
really,
look at that. I'll definitely look at that. I'll look at your charter too. Okay, thank you all very much, and I will see you in a couple weeks.
Thank you, Ms. Scott. The time is now 7:32 p.m. and this meeting is adjourned.
You guys ready to start the next meeting?
Board services, y'all ready?
The time is now 7:33 p.m. This meeting has been duly posted, and we have a quorum. We are moving into the Superintendent's Evaluation Ad Hoc Committee meeting. We've already done the pledge at the prior meeting and the salute to the flag. So let me just introduce the members of the board who are on the committee and those present. Trustee Ben Mackey is on the committee. He is not here and probably will not be able to attend. Trustee Carla Garcia is on the committee. I'm Dan Mitchkay. I'm the chair of this committee, and we're joined by our superintendent of schools, Dr. Michael Hinojosa. So let's move to item 3 of the agenda, discussion of the superintendent's evaluation instrument and 2019-2020 targets. Dr. Lear, do you want to?
I'll turn it over to.
Yeah, I will pick it up from here, and Dr. Lear needs to help me with this. First of all, before we get started, let's go back, leave this page up there. There was some discussion about why are you even starting before you have the goals that are going to be revised. Well, these are not the student outcome goals. These are not the district goals. This is part of the incentive plan that's in the newly adopted superintendent's instrument, contract. So what we've done is started on this because there is a deadline, and that is November the 30th. These need to be adopted, and then as a practical matter, the November meeting is actually earlier. It's before Thanksgiving. So this is the first meeting. It's a very high level. We have 3 incentives to lay out. We apologize for not getting them to you earlier, but I've been in conversation with Dr. Lear and our chair, Dan Mitchkay, regarding these. So there's no action we want you to take tonight. We have 3 that are baked and ready to present. We have 1 that we've had a lot of discussion about, a 4th one, but we can't come up with something that is ready for prime time. So we'll tell you what it is when we get there, and then if you want us to continue to proceed, we will. One of the things we're looking at is can you present that's quantifiable, that's measurable, that's refereed, so that there is no questioning the motives or questioning the issue. So with that being said, let me pass the deck around, and then we'll just get started from here. And we'll stop at each incentive and then talk about the why, and then get some direction from you.
Dr. Hino's, just as background for everybody, superintendent's contract provides that the board can set up to 7 goals for the superintendent, and these are performance-based goals. And with respect to each one of those goals, if the goal is achieved, there is a $20,000 compensation bonus attached to each of those goals. If the goal is not achieved, then the bonus money is not paid. And in preparing for this meeting, the administration has proposed 3 goals that we're about to go over that they've discussed with me, and then there's a 4th one that we'll talk about. And then anybody else can talk about other goals after that they think would be appropriate to consider. Okay, thank you. Dr. Lear.
Yeah, thank you for that clarification. We'll start with item number, incentive 1 on slide 2, and that's that 73% of the early college and P-TECH students will graduate with an associate's degree. When we talk, these are the 3 standalones, the Samuel and Spruce, and then the 8 that are in cohort 1 of P-TECH. Next year, this number will be bigger, but this is the current number of students that we have in this senior class. If you look at slide 3, the reason that it is rigorous is this has been our pattern of 58% to 63% to 66%, and we're targeting 73%. The national average, and we have a source there, it's AIR is a research organization that says only 1 in 5 early college high school students actually graduate with an associate's degree when they graduate from high school. Ours is much higher, much more rigorous, and then you'll see some of the other data slides that come from this one. If you go to the next page, this slide is a little different because this is all seniors. And you'll see that for all seniors, not just the ones that have the opportunity to graduate that are in a program, you'll see the percentage in the district, and then you'll see where the projection is going. So that's the difference in this slide. The next slide, we'll talk to you about, Dr. Leary, you might have to, because we also say, how can you go back and quantify the TAPER report, which is a Texas, it's an external report. So Dr. Leary, will you talk about this slide? Because I'm not as familiar with this slide, but if you'll cover this one.
Absolutely, and Dr. Lusk and Ms. Rogers and Ms. Elizalde can also come up. We thought it would be important to have a comparison slide so that we can see other districts that are large urban districts. So that's why we selected the ones that are there on the left-hand side. You can see in 2017 off to the right, and then 2018. And this is looking at all seniors. So it's not just the P-TECH and early college high school students. And, so I don't know if Usama or Dr. Lusk wants to elaborate.
So the previous school year, the TAPER report began to predict associate's degree graduates, and as we looked to disaggregate the data to compare districts, we were able to do it as a whole, and so those projections built out where Dallas ISD is comparative to other districts within the state.
So at this time, we'll be glad to answer any questions that you may have, unless Brian or Stephanie, you have anything to add.
Yeah, I think that those data, these are actuals, right, that we're looking at. So I think you may have said projections, but really these are actual data points that we do have for graduates. So Stephanie and I were just briefly touching on that, but that's a clarification point.
Also a reminder, this is year lag data. So it's always from the previous year.
Trustee Marshall.
So I just have a question, taking a step back, not specifically about this objective or this incentive, whatever terminology we're using, but should I be thinking of these as overlapping with the goals that we're going to talk about on Thursday, and that they're consistent between the two of them? Because there's been some discussion amongst trustees as to having board goals, some of which may or may not overlap perfectly with the incentives in the superintendent contract. So are these three things that are in here, you're obviously talking about them in the context of your incentive plan, but are they also going to show up on Thursday as three proposed goals for the district?
Partially, because like this one specifically, there's a college and career and military ready goal that we're required to have by the state. So this will be embedded in that goal, but this one for this incentive is separate.
So this is a sub goal of the larger goal that the district would have as a goal, but this one piece is carved out for your
Correct.
incentive plan.
Exactly.
And is the second and third one also going to show up as goals?
The African American goal will show up, and we don't have the one on F campuses in the actual.
Okay. I'm obviously not a part of the superintendent's evaluation committee. I'm just here because I'm interested, but I find it difficult to have this conversation prior to having the board goal conversation. And I recognize you're doing it because of the timeline and the need, for what you said in your intro, but
Okay. Well,
I don't know how you would have this conversation prior to the.
yeah, I mean, there is some question about, are we putting the cart before the horse?
Yeah.
But we're ultimately going to have to visit this information, and I think this is informative to go through these three goals. It might help us.
Sure.
We're not going to finalize anything tonight. We're not going to decide anything tonight, so it might help us.
Yeah, it's just
with-
pre-wiring for Thursday.
For Thursday, yeah.
All right, thanks.
Okay. Any other questions on this particular metric?
Dr. Lear, do we have another deck for
Oh, of
trustee
course.
Mack?
Maxie, I think.
If there are no other questions, let's move on to the next goal.
I have a
Oh,
question.
I'm sorry,
Mr. Mitchell.
Trustee Garcia.
Yes, question on, this is on. So what we're looking at for the incentive goal itself is we're saying we expect 668 students total to have that associate's degree to meet that goal.
Correct.
Okay. And remind me, these associate degrees are tied to high demand living wage credentials for students?
Correct, and I would say it considers the standalones as well. So it's both the pathways that I think you're referencing, high demand jobs, but also the early college standalones, which are more about getting core complete, and then offer a student a pathway into the four-year university. Do you want to add to that?
Now, a student graduating with that associate's degree would not require any remediation if they were to want to use that credential to go into more higher education, for example, in a bachelor's degree?
Well, that's something that depends. Brian and his team have been working in North Texas. I had a conversation with someone external today. In North Texas, there's a great alignment between all of our four-year institutions in North Texas and these ability to gain these associates. Now, if you apply to Texas State or UTEP or somewhere, or the UVA, Virginia, then there may or may not be agreement that these credits will apply. That is our intent, but we can't control higher ed, but we know that within North Texas, we have worked closely with every university. Brian, add?
Yeah,
or
yes, sir.
elaborate?
Just to add a piece to what you're saying, the North Texas Community College Consortium has helped build pathways to ensure that our students can go from a 2-year to a 4-year. And so, as we referenced last time, we'll have a fair for students to be able to make that connection. But yes, there are pathways for all of our students, but there are also opportunities for high-demand jobs.
And to your question about remediation, the students will be degree complete, and so they would have met the TSI for reading or taken the course to exempt them in that area.
And how does this tie to HB3 funding, if at all?
This is
For these
gonna,
students?
go ahead, Brian.
I was gonna say, can you repeat? I didn't hear part of that.
Yeah, how does this tie into HB3 outcomes-based funding, if at all?
Well, I mean, for HB3, obviously, if our students are TSI met, and then they graduate with an associate's, that's one way it triggers the funding, right? If they're TSI met and they go into enroll in college the 12th day next year, for the following year, that triggers the money. So there are multiple ways that the money is triggered, but for this particular goal, it's them completing the associates and being TSI met, which then would trigger the money.
So this is one of the most sure ways of capitalizing HB3 money. Some of the other ones are still being analyzed, but this one would be the most sure way to get funding for HB3.
Okay, let's go to goal 2.
All right, let's go to the second incentive, decrease the number of F schools to 0. As you know, we've been on a very positive trajectory in the last 4 years, from 37 down to 4, then back up to 8. You see some of the comparison districts and the percentages, but also need to tell you that now officially, since we have voted, the board has voted to support our recommendation to close 1 school, we're down to 7. And then also, let me also tell you that this is a very rigorous process, because we have 12 other schools that got a D, and if you get 2 Ds in a row, then you get an F. So if any of the D schools, so we have 19 schools that we have to get out to a competing level in order for us to accomplish this goal. You'll see, so that's kind of it. Ms. Elizalde, you had anything to add to that one? It's pretty simple. We'll know it, we do it, or we don't.
Trustee Marshall.
I love this one.
Okay.
It's on my individual goal with the superintendent, by the way, as well, as it should be.
Okay, incentive 3.
All right, incentive 3, this is, we'll go to the next slide, that 37% of African-American students will achieve at the MEETS level on the STAR in Domain 1. So where are we? Go to the next slide. You see that if we followed this trajectory from where we've been on, this is all information taken from the TAPER report as well, we would be at 35. But we're pushing the goal up to 37. It needs to be more rigorous, that students are performing at grade level, African-American students. You'll see some of the comparison districts. There are very few districts, go to the next slide, that the state of Texas is at 37 this year, so Houston's a little bit ahead of us, Fort Worth's way behind us. These are districts that have these are urban districts that have approximately 20% plus African-American students. And so for us to accomplish this, it's very rigorous, but it's the right thing to do. And we think that, and also want to make the point that we're already a quarter into the school year. So whatever things we're doing now have to work for us to get this result at the end of the year. But I think with CAP, with ACE, with collegiate academies, PTEX, with all of the things we're doing, we're going to continue to move this needle, and we think that it's realistic, it's rigorous, because we're jumping several points up to the expected outcome. So that's in a nutshell. Pam or Stephanie, anything to add to this incentive?
I'd just like to re-quantify the growth target that you've set here. It doubles what's been the general trend. So I just want to make sure that we actually call that out. It's doubling what we would think would already be hard to do. Getting a 2-point gain each year is still challenging, and so this incentive goal that Dr. Hinojosa has set is double that, to a 4-point increase from where we are.
Anybody have any questions on that? Okay,
the fourth one? The fourth one we don't have for you, because one of the things is regarding enrollment, it's regarding market share, it's regarding competing. And we've looked in many different ways as to how to measure this. And part of it is, do we just compete against charter schools, or do we also compete against homeschools and private schools? Do we also look at, despite the fact that every urban district is losing multiple students, we've kind of stemmed the tide? So we've looked at like 4 different models, but we didn't, in a short time that we've been working on this, we didn't have something we were confident to bring to the board at this time, like we're confident on the other 3 that we have. So we're going to continue to bake that if you tell us that's important to you. If it's not, then we won't put it on there. And those are the only 4 that we've had discussions about.
Okay, just to give you a little bit more background on that. So one of the ideas that we'd kicked around was that enrollment would be at least 154,000 kids next year. And our projections show that we're expecting, what,
152,000.
152,000.
Our demographic projection is 152,000.
Okay, so.
And by the way, that's PEMS data that's quantifiable by the state at the end of October every year.
And currently, we have a little over 154,000. One of the problems I had with that kind of a measure was it's hard to convince people that someone is entitled to a bonus simply because they only lost, 200 students. So we tried to come up with a different way that would be more realistic. And what we kicked around was the percentage of Dallas ISD students compared to the overall number of Dallas ISD students plus charter schools within Dallas ISD. If our percentage goes up from this year to next year, then a bonus could kick in at some level. And just to give you a little bit more background on the stats, in about 2014, there were about 159,000 kids in Dallas ISD. In 2018, it's about 154, 155, using their comparable numbers. And for charter schools, the number of kids attending charter schools in 2014 was about 27,000. And in 2018, it's about 33,000. So during that period of time, Dallas ISD enrollment went down by 4,000 or 5,000 kids, and charter school enrollment went up by about 6,000 or 7,000 kids. And trying to figure out, if this is an appropriate instrument or an appropriate place to put an incentive to change those dynamics. And we kind of left that, unresolved for further discussion. So I just wanted to give you that background. And Trustee Marshall, I'll turn the floor over to you now.
Yeah, thanks for the background. So I have kind of 3 overarching comments. One is thanks for presenting these 3 draft incentives. From my perspective, the second one is great. The first and the third one both smell to me like subsets of broader goals. Like the first goal would be this one that you have up starting there. The third one would be just an achievement gap goal, of which this is a particular subset. It's obviously the most important one, but it's one subset. And then on the first piece around the early college high schools and PTECs, I think what Trustee Garcia was referring to around CCMR for HB3 funding, I think that's probably the broader goal, and this is a subset within that. And I'd rather see your incentive package tied to the higher level goal, not the subset goal underneath it, if that makes sense. So that would be my first comment. The second one is I'm glad that you brought up your 4th idea about market share, because the 2 things that I was gonna suggest need to be on this list from my perspective are market share and passing the bond. And that's binary, right? So it's pretty easy to track whether the bond passed or not.
Stay on market share for a second, because I do want to address the bond issue.
Okay.
Do you have more to say about
so
market share?
I was just going to say those are the couple two that I would like to see on the list. And then my third comment around market share, just addressing Trustee Mitchke's comments, is I definitely think market share should be a goal. I sympathize with the idea that you don't want to provide an incentive off a loss number, which is a challenge that I think we need to figure out. However, I wouldn't agree with going down the path of looking at charter schools only, because I think that if you look at the geography of Dallas, the way that charter schools are dispersed in our communities are primarily in the southern sector. And we've spent a lot of time and energy and money on trying to attract middle and upper class families, which unfortunately in our city tend to live in the northern and eastern parts of our city, where there are not as many charter schools. And it's been an objective and sort of an understated goal of this board to try to bring some of those families back to Dallas ISD. And I think that this market share goal needs to recognize that we also need to attract families back to the district in areas where charter schools don't have a presence, and where those families are primarily either attending private schools or parochial schools. And this goal, I think, should focus on those students as well. So I don't like the idea of only looking at charter school market share gain. I think it should include private, and I think it should be all students in our geographic area.
Those are fair comments. We were not able to come up with one that we thought.
Yeah, and I don't have a silver bullet. I'm just, that's my frame of evaluation here. Thanks.
Okay. Trustee Garcia.
Yeah, so Trustee Marshall, just so I understand a little bit more what you're saying is it's more of a concern of the socioeconomic diversity of our schools and our campuses tied to market share.
Yeah, I want to improve socioeconomic diversity and at the same time improve market share in all parts of the city.
Mm-hmm.
And gaining market share from charter schools is one important component of that. But much like I articulated earlier, I view that as one subset of a broader goal. The broader goal is grow market share. A subset of that is take share from charter schools. Another subset of that is take share from private schools. Another subset of that is take share from parochial schools, and then take share from homeschooling. And I think all of them are important, and that we should evaluate the superintendent on the broad goal, not the sub goals.
Okay, we did discuss passage of the bond as another goal, and the concern with that is that the superintendent can help us pass a bond by creating a district that's moving forward, increasing public confidence, increasing student opportunities and achievement, but he can't campaign. And there's also the problem with fueling people who are against the bond, who will, and this is not an example I made up, this is one that I got from David Thompson, is that people who are against the bond will say that, well, the only reason why the superintendent is for it is because he's going to get a bonus if it passes. And it makes his actions suspect whether or not he is trying to campaign. And that's out there, but he can't. Go ahead.
I also want to add that I feel uncomfortable with it. I think, it's just part of my job to help make sure that gets done, but I cannot. Once the board calls the election, I have to be very careful. I don't even take speaking engagements because I'm very uncomfortable that I would be advocating for the passage of the bond. So Dan and I agreed that we really didn't want to go there, didn't want to put ourselves in that crosshair. It's an important thing to happen, and that's what we're going to work towards, but I don't feel comfortable that I should get rewarded for it if it passed.
Trustee Marshall.
So in the spirit of the governance training that we just received, I will obviously defer to the collective will of the board, but I strongly disagree with both of those comments. On the first one, when it comes to whether the superintendent can campaign, I absolutely would not expect you to be delivering speeches to encourage voters to show up at the polls and vote for the bond, but I do think that there are a substantial number of levers that you can pull quite legally and quite within your purview to set up a bond in a way that is able to be passed, and I think that the broader marketing communication about how the district is performing and why we need this bond are things that exist squarely within the purview of the superintendent anyway, and if we're doing a good job on those things, that leads to bond passage. So I think there's plenty of indirect levers that the superintendent can pull without violating any sort of legal requirements. And to the second point around whether there's an incentive, I just view that as background, opposition noise, and I doubt very seriously that that would move the needle on any voter's approval. And I would just conclude by saying that I strongly believe that passage of that bond is probably the single most important thing that the superintendent could do in 2020 to improve student outcomes. And if it's the most important thing that we need to happen as a district, it should show up on the incentive plan for the superintendent. So I feel very strongly that it should be on the list, and I don't buy in at all either one of those arguments, but I will defer to the collective will of the group. Thanks.
Anyone else? Dr. Hinojosa, anything else?
No, sir, I just need some direction. Sounds like we do need to come back with something on market share. We'll continue to, we were very close on 2 or 3 things, but at the end, we weren't quite ready, and I hadn't had full input from my entire team. We do have a team meeting on Thursday, so we'll cover that again, and we'll have something for you to consider. We may bring back like 3 different options for the for the fourth one for market share, so you'll have multiple things to consider. So let us bring that back. We have when's our next committee meeting?
The 5th, I believe, 5th of November.
If our next meeting is the 5th of November, let me just kind of tell you the timeline. We have the briefing like on the 6th or the 7th, right?
The 7th.
The 7th, and then 2 weeks later, you vote up or down. So, and of course, I think my contract says I have to agree to them, right? I think it's what it says in there too. So, anyway.
I don't know if it says you have to agree or you get to be consulted, but okay, President Henry and then Trustee Flores.
So when you're talking about the recapture of charter or private schools or other, and I don't know if you can measure this, but to the extent we can measure folks that are even, leaving the district at certain levels and how we can get them back. Leaving the physical bounds of the district and going to Mesquite, Garland, et cetera, Addison. I don't know if that can be measured, but.
We have a version of that, but we weren't real comfortable with that because maybe Cecilia or Velia can tell us if we can actually have a PIMS number that the student has and how many did we actually keep. That may be I know that was not part of the retention plan you gave me, so that's why I wasn't comfortable with it. But I'd like to know how many kids that had a PIMS number with us last year are still with us this year, and what is the percentage and what history do we have? So that's another consideration that we can kind of put together if that's possible. But I don't want to speak for Velia or Cecilia about whether that's even possible. Cecilia's nodding, yeah.
I think it's possible. I think the challenge is then we'd have to look at the net, because we have some kids that were here, obviously, that didn't stay with us, and then how many more? There's such a revolving door.
And you got to consider graduating seniors and how many new pre-Kers do you have? We started getting in the weeds on that, and it was
And then
just too
like the
deep.
student could be with us, then they went to a charter, then they could have gone to a private, then they came
come
back to
right before the
us.
STAR test.
And there's
So, yeah, it
actually
was
quite a bit,
complicated.
it's not real clean.
Point of information to the superintendent that, I don't know if you remember, but 3 years ago, you gave us what you called our Christmas present. It was a binder for each one of us of the schools in our district. And it had, for each school, it showed, this school has 50 kids and its attendance boundary that go to this charter school. And there are another 60 kids that go to this private school. That was the best level of detail I've seen on market share, and I saw it in that binder 3 years ago and haven't ever seen it since.
Yeah.
I would
I
love
think the
that to be the
demographer
basis
is paid.
on which we were calculating this number, and ideally you would calculate it on a student by student basis, but we don't need to see it on a student. The goal doesn't need to be tied on a student by student basis. It can be aggregated and say, we may have lost these 10 kids, but we gained these 20, and the net went up, and so you met your goal.
Yeah, we'll keep working on that, see what we can come back that's coherent.
Trustee Flores.
So just to follow up on a couple things, so in terms of like the number, I mean, I think that there has to be some way of measuring market share, whether it's transition from, pre-K to first, conversion, from pre-K to first grade, from 5th grade to 6th grade, from, 8th grade to 12th to 9th grade. I mean, that potentially, I don't know if that's possible. Now switching over to the bond, however, I agree with Trustee Marshall that I think that it's something really important and really impactful for kids. Another way of doing it, instead of just like the passage, because if that's in December, then that's kind of after the fact versus where we are in terms of the timeline on this. But another thing could be, because I think it's something that's very important that revolves around transparency and governance and what the board, the process of getting to the bond is perhaps something like having a supermajority vote in favor of passage of putting it on approving the plan to put before the voters. Because that's about process. That's something that he does control. That's the ultimate outcome of the passage of the bond will have to do with how good this bond package is and whether we believe that bond package is something we want to put before voters. And that's something that, wouldn't have the political issues because, in fact, it's not about the ultimate passage. It's about the plan and the plan that we're going to put before the voters. And that do we think it's the kind of transparent, work that went into building it to then passing by the board? It's just a thought.
Yeah, and I think that's a very good point, but I think all the ones we're presenting to you, we would have the actual data to meet with the contract requirements that the award be given by a certain date next year. The only one that didn't was one of the market share ones we wouldn't get till the following spring of 2021. And that one I vetoed because, well, now we won't, that'll be future, and we need to just tie it. So we're also looking at what is quantifiable, refereed externally that, yes, you did. Like the bond is, we'll know because we'll know the election results on November 2020. And we'll know that as meets the requirements of the contract. So we'll take that into consideration, but I still feel a little uncomfortable with that one.
Okay. One other thing. Oh, go ahead.
Can we go back to November 5th? What are we supposed to be doing on November 5th?
November 5th is going to be the date of another superintendent evaluations committee meeting.
Can we move that to another date? We have a national holiday on that day. It's Dustin Marsh's birthday. Can we?
Well, actually, neither one of you are on the committee, but
Okay.
you're welcome to come and enlighten us.
Y'all are messing up the committee.
Well, I would say one thing about the time lag. I actually don't think that that's an overriding consideration, because even if we have to calculate it 18 months from now, it's still an important goal, and you're still going to be able to get paid for it if you earn it. So we don't want you to not be working on a goal that we otherwise think is really important simply because it can't fit within the 1 year period. So ideally, they'd all fit within the 1 year period, but I wouldn't chuck a really good goal or incentive simply because it can't be measured exactly within that year time frame. And the second thing on the bond, I don't know what kind of benchmark data we have. It's probably worth a call to David Thompson, who's done a lot of bonds himself, and see how many. There aren't that many, I think, school districts that have incentive plans for their superintendent, but maybe see if there's any precedence out there on giving a superintendent an incentive payment based on the passage of the bond. If it's way more common than we're assuming, then maybe it's not an issue. But if this is the only one that's ever been done, maybe, we'd feel less good. Okay. Anybody else have anything? Yes, Trustee Garcia.
Not on the bond, just going back to this third goal on student achievement. explain to me just the rationale for achievement versus potentially growth for our students.
Ultimately, growth is still utilized, obviously, in the accountability, but the intent of growth is to essentially not have growth and move towards absolute performance. And since most of our schools are still in growth model, this was a comparison of not just saying, so that we're actually comparing, because growth models are still based on either 2A, which is student individual growth, how Stephanie does from one year to the next, or relative performance to students who are like Stephanie in another setting. To really compare that from one school or one district to another, you could still meet your growth goals and still not be anywhere close to domain 1. So part of this was that in order to truly say we're working to close the achievement gap, it really has to ultimately be on domain 1.
In addition, this is the student group that we're the furthest behind, and you need to call it out in the name of racial equity and double your performance to catch up to the state and to pass Houston. You really has to be about absolute performance, and this is at the college ready level.
Yeah, this is specifically at the meets level.
Okay, the time is now 8:11 p.m. and this meeting is adjourned.